superpower because they give a lot of importance to this aspect. And whenever the President of the United States speaks, he brings up this. Like when in some context, whenever they have such meetings happening, so they speak in terms of innovation. Okay. So the economy and the protected knowledge are closely interlinked. How do IPR work and the IPR law? Like the movable and immovable property, intellectual property is also governed by the law of the country. Any country, like its intellectual property is restricted to their respective country law. It may differ slightly when we talk of the intellectual property protected by law, the law in the US and law in India. There is a global framework, but some aspects there may be some difference in law, but overall the intention is the same. So it is protected, governed by the law of the country, which is for the timing in force, namely law of intellectual property rights. So remember always that intellectual property is the property that comes up from human intellect. When that is protected by law, it is called intellectual property rights. There is a law of intellectual property rights, and it is derived through the parliament. Means we are all people. That's how we select MPs, and they select prime minister and ministers. Like that it happens. So anything associated with this, it is passed through the parliament. That's how it has become law, and it is in force. So application of the intellectual property law, rights law, you come across patents for new inventions which are solutions to scientific and technical problems, industrial designs which are aesthetic creations, determine the appearance of industrial products, trademarks are useful for the consumer for the identification of manufacturer of products, copyright, which are the rights in literacy, artistic software, etc. Actually, I'll take you through in detail, because I don't know really how many of you are aware of, as I am in the slide mode, it would be a bit difficult for me to be interactive with you. Otherwise, I would have asked questions like how many of you are aware of the basic things first, because we move from the basic to the slightly higher level, and that's how I will be talking of the application. Of course, I will not confuse you. So I will take you along. So I hope you will be able to catch up with me. So what is the term? Now, I would like to tell you, when we are talking of intellectual property rights, there is one term you will come across. Always remember that industrial property. Actually, industrial property is a subset of intellectual property. Let me tell you, the commercial value of any industrial product depends mainly upon utility of product and cost of production. So invention, that is what I think I'll not go through this slide because it is too many things I have to cover. So I'll tell you, like intellectual property rights, when it is patent, design, trademark, all concerned with industrial product, it is what is industrial property. But there is some aspect which is not directly connected with industry that way, that is added later. In the next slide, what you can see is the copyright thing is added. So when the copyright thing has been added to earlier whatever they were calling industrial property, now it is altogether is called as intellectual property. I hope you understood this. So earlier, patent, design, trademark, they were mainly called in relation to the industrial activities. That is why they were called industrial property. But in due course, there is one more term, or one or several of that kind were added to that. So that, for example, copyright is added later. That's why they can't call it as industrial property. That's why they put in a new term called intellectual property. But in some documents, you come across these terminologies: industrial property, intellectual property. That is why you should not get confused. So industrial property means subset of intellectual property. So industrial property means mainly patent, design, trademark, like that. But intellectual property will also involve the copyright and other related aspects. I hope it is clear to you. So moving on, when this IPR protection started, it started way back 2 centuries before. In 1856 itself, the things started moving. And when it came into existence in India in 1911, during the British time, so in 1911, the Indian Patents and Design Act came into force. And as we moved on, in 1970, actually there is a 70 Act actually. Okay, you see the 1972, the Patents Act, that the Act 39 of 1970, which came into force on the 20th of April 1972. There onwards in 1999, 2002, 2005, like that amendments happened. So moving on. Okay, there are variety of things. I will skip this slide, but just I would like to tell trade-related intellectual property, trade-related aspects of intellectual property rights. They were talked in terms of World Trade Organization. Okay, now let me come to one by one. If you don't mind, let me take my tea. Okay, in parallel, let me go through that. So, see, what are the protection available? Patents, trademark, designs, copyright, circuit layout rights, plant variety rights, trade secrets, geographical indications, utility models, protection for living organisms. So, you see a big list here. So, you should know one by one. If you are you are going to run your company in future, you do a startup, then you should know which are the type of protection you are asking. Okay. So what is a patent? It is a set of exclusive rights granted by a sovereign state to an inventor or assignee for a limited period of time in exchange for detailed public disclosure of an invention. An invention is a solution to a specific technological problem and is a product or a process. So remember, when you talk of patents, it is a product or a process. Anything, product may be a chair or a table or whatever. Okay, or a car, they are all products. Okay, aeroplane is also a product that way, like it's a bigger assembly of so many components. So product or a process. So this is what earlier there was a problem like process, they won't give the patent, but now in the latest amendment in India, process is also considered for patenting. So that is what is the, like these are all the patents you see. For example, the different type of chair designs. So there may be something available. So when you improve, that improvement has to have the functional aspects, and it has to have the economical aspects also. So otherwise you'll be infringing on somebody's work. Okay. So this is patents. So move on quickly because I have to take you through so many of these things. So as I told, Patent Act came in 1970. Of course, 1911 it came, but as an independent nation, Patent Act came in 1970. Then patent, when Act is there, it was amended in 1999, 2002, 2005. That is the Act passed through the Parliament. Then it has to be implemented. So that is why the rules have to be there. So the rules were framed in 2003. 2005, of course, there were amendments. Amendments keep on happening. So 2005, 2006, because there are concerns, not only of the local, global concerns. Some countries they raise issues that this is not in line with the global requirement. That is why these things need to be changed sometimes. Okay, that is why those amendments happen. So from 1995, 2000, 2005, like that, they have made changes in our patent law in such a way that we have met our international commitment. That's extremely important. Otherwise, you may be seeing like when a prime minister goes at the summit level. Summit level means all prime minister or president at that level when they go, there will be a lot of such trade-related meetings when they go. These are all the things are discussed that your country is having discrimination. So that is why when they say like that, prime minister at that spot, he can't change whatever it is. He has to change it through the parliament by the will of the people. Who are the will of the people? 1.3 billion people. When they give their consent to their MPs, it is believed. Like there may be opposition, but everything when it agree and when it is passed through the parliament, then only it will become a law, and then only the changes can happen. Then only it can meet the international commitment. So that is what has happened from time and again. It has amended, and now we say that we are meeting the international commitments with respect to the IP rights as well as particular reference to patenting here. Moving on. So what is a patent law? It is both product and process patent. As I told earlier, term of patent is 20 years. Examination on request I will go slightly in detail later. I will tell the entire process because I will not be devoting much time to other aspects of intellectual property rights. I will be taking you more through the patenting. So there will be when you file, there will be an examination. Both pre-grant and post-grant opposition would be there. I think I will not go through this. Okay, there is a patent law. Remember that it has a life. Once the patent is granted, it will have a life of 20 years. Remember like that for the time being. Then there are the other aspects also. I will not tell about that now. Okay, now moving on from the patents to the trademark. What is a trademark? A trademark is a word or a slogan or a design, picture or any other symbol used to identify and distinguish goods or services. You can see trademark just it is a trademark TM, but if it is registered you can see R. Okay, this is the symbol. Whenever you look at some of the things like this, like you see here R is there, that means it is registered. That doesn't mean if they don't register, but they still use as some word or slogan or design as a like this, say Kalyani, and R is not there, but somebody uses the same logo, and if Kalyani goes to court, he will win because he can prove that I have been using you from time immemorial or whatever time. He can tell in the court that I have been using it, and he will show the proof. So I can't use this Kalyani logo and use it. Okay, so that is how it is protected by law. Even if he takes unlike patent, in this case trademark, it may be registered or may not be registered. If it is registered, there is you can see R associated, like what you see Coca-Cola has R here, but Kalyani has no R, but still they have the right. Okay, it's by law it is protected. So this is what is the trademark. I think all of you are aware. Like Bosch is invented for life. So this is what is that. It has a logo. It has a slogan in that. Okay, Bosch is the name of the company, and they have a slogan as well as you see a mark here. Okay, so that is what logo we say their company name. Then this one is there, and also some slogan is there. So trademark registry was established in India in the year 1940, and presently it is administered the Trademarks Act 1999 and the rules thereunder. Okay, moving on, I will move on to trademarks. These are all the further details on trademarks. Moving on, design. You come across anything aesthetically visible to you. For example, a shape of a car. Like let us take the shape of a car, whatever. Let us say now Brezza is there, Maruti Brezza. It has a particular aesthetically, it has a particular geometry, right? So if Tata takes that shape exactly like looking like Brezza, he makes, then Maruti can go to the court and win over them. Okay, then there will be a penalty on them that you have copied their design, aesthetic design. So this is what is the meaning of aesthetic design. When we make any car or any light post or whatever, if the aesthetically looking something, another company or another individual, they can't copy it. They have to make deviation of that, and that is how it is. So it is also protected. Moving on further. So there are some years of protection. Okay, some are like patent is 20 years, design is 10 years, like that, and also they all depend. Copyright is 50 years or till the or even beyond the death of the author, like that and all. But there has to be fee to be paid. Like if it has to, the right has to remain with us, then there are government fixed fee are there that needs to be paid. Moving on, copyright. I think I'll encourage interaction a bit later. Let me cover all these things, and when I move to patent in particular, that time you may ask questions regarding these if you have any doubts. So let me give you a brief of all these different types of intellectual property which are covered under the law through the intellectual property rights. So we have the copyright, a right owned by every author of a work to exclude others from doing any of the following activities in connection with that work: reproduction, adaptation, distribution to the public, performance in public, or display in public. Okay, a poem, artist drawing, painting, computer software or program. You see here, computer software program is a copyright. It's not patent. Okay. In India, covered by Copyright Act 1957. You saw Trademark Act 1940 during the British time. So this is after the British 1957. Patent as in other year. Okay, like that. So term is 20 to 70 years. Literary work 50 years from death of last author. This is how it is. Okay. In general, the term is 20 to 70 years. But when it comes to a literary work, 50 years from the death of the last author. That means if somebody, for example, Dr. Shivaram Karant has written a book, and we can't just copy it and I can't copy and sell it. I have to take whoever is the after his death, whoever is what is that? There will be caretaker, means whatever their property owner, right? So they will have we have to take their permission if you want to reproduce it. So this is what is copyright. When computer program comes under copyright. Only computer program integrated with the hardware, then only it can become a patent, because it becomes a product. Okay. Otherwise, it's not a software is not a process also. So it is just a human intellect on the paper or on a disk like that. Okay. So it is not considered as a product or a process. Okay. So that is why computer program comes like this. But when the computer program is integrated with the hardware, then the hardware can be patented. Moving on to circuit layout rights. Actually, that is where the problem. These circuit layouts earlier were not protected through patenting. That's why they brought a new system called circuit layout rights, especially in electronics or in the computer field. Many of the integrated circuits, which are highly, like if you see the present day, whatever we are using, the system has become so compact, and it may have so many circuits in that. So all those are covered through the circuit layout rights. So it's a special right. So it is not covered under patent, but under a circuit layout rights, because there are some complexities. That is why that is not taken through patent. So it is circuit layout rights. Similarly, plant variety rights. So I will not go through these details. Okay, just you should know that these are all the variety of rights available to you. Plant variety rights. It's mandatory to provide protection for new plant varieties under TRIPS, trade-related intellectual property rights provisions of World Trade Organization agreement by one of the two options. So the country has to protect plant variety right by one of the two options what you see here, either under patent law or by a separate system called sui generis system. Okay, it's a name which has come from other country, sui generis system. In India, Parliament has passed the second option, that is a sui generis system under the Protection of Plant Varieties and Farmer Right Act 2001. So remember, when it comes to plant variety, you can't say that I want to patent this plant. Okay, not allowed in India. Some country may have patent, but India has no. So India has adopted a system called sui generis system. So you should know that when it is pertaining to plant variety, it's the sui generis system. Now we'll move on to the trade secret. So very important aspect of trade secret, like KFC or Coca-Cola. Nobody knows what is its formula. Okay. So it is so much protected that even their employee want to come to know. If there are 10 ingredients, 2 items are kept at some place, another 2 or 3 items kept another place, another 2 or 3 items kept another place. Now with the computerization and all, what happens? It takes the appropriate this thing and it mixes. Otherwise, in earlier days, they were taking the appropriate this thing and mixing, so that nobody will come to know what is the total means what is the ingredients in the total. Okay, so that is what is kept so much of secret. So it is called as trade secret. So it is not to be registered. Okay, so but if somebody violates and create Coca-Cola can go to the court saying that he has copied me. So it's not allowed. So if somebody is existing in the field, nobody can copy that and create the same thing and say the same thing. Okay, so that is what is very important. So information that has commercial value and that has been scrupulously kept confidential, means intentionally kept confidential, will be considered a trade secret. Owner will be entitled to court relief against those who have stolen or divulged it in an illegal manner. Either they can't use this logo symbol and all, that also not possible, or they can't say I have the equivalent thing of Coca-Cola or KFC like that. That is also not allowed by law. Okay, so that is protected. Even there are stories, somebody is stolen and like that. I don't think so I'll have time to tell you those stories. So trade secret, trade is provides competitive advantage, potential to make money. So the secret part is kept confidential, so nobody knows what are the ingredients. Okay, 3 essential legal requirement for trade secrets. So they have to really have this requirements to be met with. Otherwise, in the court of law, they may get defeated if the opponent proves that these people didn't keep it secret. So the information must be secret. It must have commercial value because it is secret. Okay. Owner must have taken reasonable steps to keep it secret. So when it goes to the court, the owner must be able to prove all these things. If the opponent proves that it was not kept secret, or it has no commercial value, or he didn't take proper step to keep it secret, then the opponent will win. Okay. But you can see more than a century or so how Coca-Cola and all they have kept it secret. It's really a great secret. So typical examples of trade secret: business plan and strategy, new product names, financial projections, marketing plan, unpublished promotional material, cost and pricing information, sales data, customer list, so on and so forth. There are some items come under the trade secret list. So, okay, let me, because it would be interesting, KFC recipe. White-suited Colonel Harland Sanders created a tasty recipe coating for chicken about 70 years ago, comprising of 11 herbs and spices. The recipe is used till date in KFC. Initially, he was having a recipe in his mind. However, later he wrote it down and hidden it in a safe in Kentucky. However, later the recipe was made known to only a handful of employees through non-disclosure agreement. Okay. It is said that further protection is provided by two separate companies, each blending a portion of the mixture and standardizing the blending through a computerized processing system. Rumor is that the employees who know the secret partly cannot ever travel together by plane or auto to further safeguard the secret. See, this is what he has put in place. They can't travel together also. Moreover, once when KFC modernized its security system, the recipe was temporarily moved to another secure location via an armored car, which was further guarded by a high security motorcade. So this is how they moved from one place to the other place. So much was secrecy was maintained. If he is not doing that, then if somebody steals, then they go to court. Then if they prove that he has not maintained the secrecy, then he will lose. Another is there. So I will not. I think it's similar case. I will not go through that. See here, this is a case of Listerine. All of us use for mouthwash, especially with respect to gum problems and all. So in the 1880s, Dr. J.J. Lawrence invented the antiseptic liquid compound Listerine. Then he licensed its secret formula to J.W. Lambert and the Lambert Pharmaceutical Company. Their successor, Warner Lambert Pharmaceutical Company, dutifully paid royalty to the Lawrence family over the next 70 years, despite knowing that Listerine formula was revealed along the way. It was revealed to the public. Okay. So it sued, that the company sued for a judgment that it was no longer need to pay the licensing fee. But the court sided with the Lawrence family, saying that it cannot do anything if the trade secret was legitimately discovered by others. See, even if it is legitimately discovered by others, then also he has to pay the royalty to the person who has done the invented the thing. However, Pfizer had the business advantage as the product was trade secret for a long time. Okay, there are several such cases. I will not go through it because it will take a lot of time. Now, moving on, geographical indications. This is a very important thing to understand. Like you might have heard of Assam tea or Kanchipuram sari or Banaras sari, like that, and all. You come to know how come these things come. Because they are of the particular geographical area where that particular material is grown, as well as the particular like a craftsman will be there. They will not be there. You can't find, because it's the local area conditions. You can find that such people are there, such skilled workers are there. You can't find them here. And similarly, whatever our nearby area, what is that? Your Bulla. Or your that jasmine, what is that, Shankarpura jasmine? They are also now having these geographical indications way they are protected. Similarly, Kanchipuram sari, for example, what China did, they took some viewers from Chennai way back, some 10 or 15 years back to China, and they wanted to produce Kanchipuram sari from China, but India took objection. That's how entire thing was dismantled. that is what is the protection for the geographical indication. So nobody can copy. Now all over the globe, because they come through the traditional knowledge, so means they come through the geographical indication, and somewhere the traditional knowledge also is connected with that. So nobody can copy that. So it is pertains to that area, and those area people should get the benefit. Otherwise, if Chinese people copy, what those Kanchipuram people will have, because their livelihood for generations it has come through this business, and they will lose their entire business. That is why it has been protected under law. Then there is a utility model. Of course, it is not applicable to India. It is in the US. Then protection for living organisms. This is the one. Um, when the patent system was evolved many years ago, it was the assumption that technology can be developed only using the tools of physics, chemistry, and engineering, and the possibility of using the tools of biology was not recognized. Okay, but later they found, yeah, a lot of things can be done through biology. That is why protection for living organisms have been given. There are some concerned areas. They are not allowed, but in some areas for living organisms it's allowed. So can an invention or product be protected under the plurality? Now you have gone through several intellectual property rights. Okay, so can you protect it, a certain thing under several of these? Yeah, the answer is yes. For example, a new drug and a process for preparation of drug can be protected under the patent law. Okay, the drug is a product, and to make the drug you have a process. So both can be protected under the patent law. If the drug is enclosed in a container having a design which is new and original, the design of the container can be protected under the Design Act. So you put that drug in a container, and that container is totally looking new. Nobody has made that type of container. So the container can be protected under the Design Act. And if the drug is to be sold as a brand name, like Anacin, for example, the said mark can be protected under the Trademark Act. So Anacin, as such, it becomes a trademark, and nobody can use the word Anacin henceforth. Okay, so that is what it is protected under the law. So the law comes under its favor is Trademark Act. Okay. Finally, if there is a pamphlet giving details of the composition of the drug, the dosage, etc., the protection comes in the copyright. Okay, so the copyright for the contents of the said pamphlet can be protected under the Copyright Act. So you see, one simple drug, it is manufactured, so is the process. So drug is a product, both can be patented, and the drug you put in a container, the container is looking new, that container aesthetics can be protected by Design Act, and then you have to sell it by some name, not the chemical name, but general, which is a very useful, people can talk easily. So you name it something like Anacin, for example. Then you have that name, so that name nobody else should copy, because you know that name, the moment you tell, it comes from a particular manufacturer or from the particular company. So nobody can use that name. So that is how it is protected under Trademark Act. And now you have to give the prescription details and other details of the drug, not prescription details, I meant to say, but the composition of the drug and all. So you make a pamphlet and how exactly is to be taken and all. So you will make a pamphlet. So that will be the covered under the Copyright Act. Okay. So a car is the best example for plurality of IP rights application. So you see industrial design for the aesthetics. Okay. Then semiconductor topography products are there, because nowadays the car is no more mechanical. It has a computer, means it has your coding, it has your electronic sensor, this, that, and all. So that has to be covered under Semiconductor Topography Product Act. Okay. Then you will have computer program by itself, so it will come under or driving control system and software program come under copyright. Engine and such things which are mechanical type of device or product, okay, they will be covered under patent. Now the logo and all come under the trademark. I think these are all the things, when it is told to you, it would be very clear what are the different aspects of the intellectual property rights that are available to you to protect yourself so that others can't steal it. So in India, how exactly you can go ahead? So there is Controller General of Patent, Design and Trademarks. In short, it is called CGPDTM. So patent office is there, head of or in NITTE. So NITTE people can apply, in Chennai region because it comes under the south. Okay, so any patent it goes to the Chennai branch. Okay, depending upon our geographical locations where you are located, they have overall subdivided India respectively east, west, north, south like that. So we will be doing under the Chennai branch. Okay. Now coming to the design office, that is in Kolkata only. So you have to apply there. Then there are some training institutes and all in Nagpur, because when you talk of patent and all, there has to be sufficient manpower who are really trained to deal with, because everyone will not know everything. That's why when it goes for inspection, the people have to come and test, or we have to go to them and tell this is what is my product. So you test, and if there are not good number of people who are trained to test our product, then they don't know whether to give patent or not. That is why there has to be enough manpower trained. So there are institutes at Nagpur, variety of institutes which are located in Nagpur. Then there is a trademark registry. Okay, head office at Mumbai, then a branch office at Delhi, Kolkata, Chennai, and Ahmedabad. Then geographical indication, I told you, like these Kanchipuram sari and things like that. So that is a geographical indication registry. So if I have something new in the geographical indication, then the office is at Chennai. Likewise, the offices are located all over India for the different intellectual property right applications to be made, and accordingly we can make our items protected. So what is a patent? Now I'll go through in detail about patent, and before that, is it Mr. Balaji, half an hour is done already?
Yes, sir.
So
half an hour over now.
Over, right? Okay.
You can take another half an hour, sir.
Okay. Anybody has any question? Anybody has any question so far? I will
question either through chat box or
yeah. Please put it.
Questions.
Yes. At the end we can answer it. Okay, I'll move on because there will be time constraint, because it's a very vast area, and if I don't tell all these things and just talk about patent, then you'll be confused. That is why I have to cover everything in brief. Then I have to go in detail of a particular thing. Okay, so now let me talk about. You are all able to see, right? So, is it a full screen is visible?
It is full screen, sir.
Okay. So what is a patent? Patent is a grant in the form of a document by the government given for disclosing a new invention by an inventor or a group of inventors or an applicant. Okay. It gives the inventor or the applicant exclusive right to sell, manufacture, and use of invention disclosed in the patent. So if I make one product, I can get that right to me on my behalf only, so that I can make it and sell it, or I can license it to somebody. So I will have all such rights in that, provided I have to apply at a proper time to the government. And there are, I told you, those are all officers. So I have to make application to them. There are some fee to be paid and all, and it has its own process time also. Like patent, it will have its process nearly dragged to 5 years. The day you file till it is finally coming as in your hands. So it will take 5 years. After that 5 years, it is having the 20 years life. Okay, for first 2 years, you need not have to pay money, but third year onwards, you have to pay every year some fixed money to the government. Now I am a patent agent. I am 2006 registered. Means I had to face a Government of India exam. So I passed in the exam. Then I had to pay a fee to the government, and it was a one-time fee for 10 years. Okay. And that is how it was continuing up to 2016. Then 2016, as I am here, so I just missed it. Then I had to pay some fine also. Then it could be resurrected, means we could correct it, and so that's how I have to keep on paying. Even if I have passed the exam, that doesn't mean that I can keep quiet. So I have to keep paying to the government every year some fixed fee. Then only it will remain till whatever the life of the person, it will remain. So I am a patent agent like that. Similarly, patent is granted for a limited period of time. As I told you, the application process, everything till the grant takes roughly 5 years. Then after that, when it is granted, then they will give 20 years time. And that till that 20 years, nobody can make it without your permission. Okay. And if they make, you can sell it to them, and they can pay you one-time money as well as the money that is coming with respect to the sale of it. Okay, that is what is called as royalty. So these are all the benefits of having this law in place. Okay, so there are several. If you go through the patenting document, which is available, big document is available in the Indian Patent Office site also. So it has all these laws given there in simple way that. See, one more thing I'd like to tell you. The patent agent earlier, anybody BA, BCom and all could become a patent agent or a patent attorney. Nowadays, the government has restricted. The lawyer also have to have to pass this exam, or they must be from the science background. Actually, to pass this exam, they must be from the science or engineering background. Others are not allowed. So in between, they had gone to court. I don't know what happened. So this exam didn't happen for a few years in between because some lawyers had gone to the court. So finally, Supreme Court gave some decision. I don't know about its update on that. But this is what the law was such that it is because it's not India. It is globally. They have said that this is what is the minimum qualification required. So they have said the science people have to be there. That is how means they can understand easily. That is the reason maybe. So if you go through that patent site, you will find a document, beautiful document. You can download it, which will have all these things very clearly said. Okay, but I am just telling you that what are all those law and how exactly they have section. Anything government, you read their document, they will have section because it's passed through the parliament, right? So accordingly, as per the section. Because if it goes to court also, these sections only they will tell, oh, a section according to section 2(1)(j), you have violated it, like that. Okay, so that is why they have very clearly written it. Invention means, as per the section, means a new product or process involving an inventive step and capable of industrial application. You see, word by word, which has its importance. What is the means invention? It is means a new product or a new process which has to involve an inventive step and capable of industrial application. It's very clear, word by word. So if there is no industrial application, you are not supposed to, it is not an invention and you can't apply for patent, really speaking. And when you apply for it, they will preliminarily see whether it has all these components. If they see that it is there, then it is accepted. Otherwise, initially itself, they will reject it. So patentable subject matter, it must be a patentable subject matter. Invention must relate to a process or product, or it can be both. Okay. It has to be new, that means novel. Novelty, when we say novel, it has to be new, novel. Okay. Involves an inventive step. It is not just abrupt. You have to have it as a systematic step. Be capable of industrial application, not fall under section 3 and 4. Now you will come to know what is section 3 and 4. Okay. There are some items which are prohibited as per the law. You can't say that I have done this and please give me the right. The government will say no, because they have already clubbed under these sections some of the things which you can't do. So what is that? New means invention must not be published in India or elsewhere. See, you must always be keeping in mind that you have done something new. There is a provision in the law that whatever comes to your mind in the beginning, you make some of the minimum thing. I'll tell you what is that minimum thing. Then you immediately file. There is a provisional application, you file. Okay. Similarly, in other rights also, like copyright and all other, there are other conditions that you have to follow. But in patent, I'll tell you, when you come across some product idea or a process idea, then you have to put it in paper properly, and there are minimum requirements. Then you can provisionally file an application. After make the provisional application, then you get 1 year time to make it perfect and put the claim and claim it for yourself in the patent office by paying the relevant fees. So when we say new means invention must not be published in India or elsewhere. So see to it that is not published before, because then if you publish, everybody will know about it. That is why don't tom whenever you do new work. Don't tell everywhere. You keep it as restricted as possible. Publication is allowed under some circumstances, but not under every circumstance. Because when the matter goes to court, they will reject it because you have published. That is why publication also you have to consult the concerned, like a patent agent or a patent attorney, you must consult. Can I publish? Under which circumstance I can publish? Then only you can publish, and at the same time you can apply for patent. Otherwise, if it's published, you lost your case in the beginning itself. Okay, that is not allowed by law. In prior public knowledge or prior public use within India, it should not be prior public knowledge or prior public use in India. Actually, not only India, it is global. When you say prior search, prior art search, you should be searching everywhere. That such a thing is not there. Claimed before in any specification in India, it should not have been claimed. Means somebody has made a claim, then you can't file it. Okay, so it's not new. What is an inventive step? A feature of an invention that involves technical advance as compared to the existing knowledge. So it has to have some technical advance. When we say inventive step, it has to have technical advance, have economic significance, or both. It should be technical advancement and economic significance, or it should have both, and make the invention not obvious to a person skilled in the art. So a person who is skilled in the art, it should not be obvious. Okay, it should not be obvious. Obvious means it should not be simple. It should have, that means that's what it says. It has a new step in it. So he will take some time to understand that. A person skilled in the art also will take some time to understand that. That is the meaning of it. So industrial application means invention is capable of being made or used in any kind of industry. Now section 3A, you have seen earlier, I told you section 3 and 4 are exclusions. So some of these are not allowed to patent it at all. Like for example, if somebody says frivolous invention contrary to well-established natural laws. Now thermodynamics says that whatever process is there, it can't be 100% efficient. For example, in the case of engine, it says Carnot engine is the most efficient, it can give 100% efficiency. All engines are maybe 30%, 40%, 50% maybe at the maximum efficient. Or you have cogeneration, waste heat recovery and all, then it could be around 80 to 90% efficient. There is no machine which is 100% efficient, then it will violate the law of thermodynamics. Okay. Similarly, perpetual machine, a machine, like how we survive, we eat food and we can move. If you don't take food, then you have to die only. Likewise, machines also, no machine will work on its own without giving food to it. Like the vehicle moves because we give the food as fuel. Okay. Similarly, we eat the food which is the fuel to our body. Okay, like that. That is what whatever known things are there. You make contradictions to that which you can't prove, then it can't be filed. Section 3B says commercial exploitation of primary use of invention which is contrary to public order or morality. Like a gambling machine, if you make a gambling machine and you say, I want to patent, that's not allowed as per law. Device for house breaking means stealing, breaking, robbery. I make one new device and such that in one this thing it will break open the door. You can go to any extent and steal the house. So these things are not allowed. Section 3 we continue commercial exploitation or primary use of inventions which cause serious prejudice to health or human, animal, plant life or to the environment. Like for example, I can tell you. Like these are an example, biological warfare material or device, weapons of mass destruction, Terminator gene technology, embryonic stem cell. These are all not allowed. Embryonic stem cell means embryo is taken within 4 or 5 days of that, and there are a lot of contradictions like controversies whether the human, whatever male or female in the embryo, whether it is getting whatever at that time the personality is there in that or not. There is a lot of controversy. So that is why they say that even if it is 4 or 5 days old, it is not supposed to be taken, and also it can lead to a lot of abortion issues and all. That is why it is prohibited by law, these things. So anybody making these type of claim, it's not at all taken in the patent offices all over the globe. And section 3B excludes patent on genetically modified microorganisms, okay, which do not, that's also not allowed. I will quickly move, okay, because there are a lot of things. I think these are all the exclusions you should remember. If you go through that site, you should remember that there are exclusions. Because of the time constraint, I will not go through all, okay. Newton law, it is a discovery of scientific thing which is already known. Then you find out something new that is also not, which is already existing, but you say that I have found, it is not, it can't be patented, okay. The name may be there coming to you, but you can't patent it. Similarly, natural occurring microorganisms, it can't be done. Section 3, a mere discovery of a new form of a known substance, which does not result in enhancement of the known efficacy of that substance. Section 3D. Okay. Similarly, there are so many, you should know that you can go through it yourself. What are all the exemptions? I think because the time constraint, I will not go through it because it will take a lot of time to explain. Like similarly, we can't have several things mixed together and say that this is a new thing which is coming out. Like for example, you fix your umbrella and you attach a fan to that. The two are doing two functions separately. But you say that this is what I want to patent. I think in Kerala somebody recently has come up with one umbrella which has what is that like our phone, no? It can switch on the phone and all, something they have made. So those things are all known to us, so it can't be patented as per the law. Okay, so I will not go through the details of this exclusion. So there are a variety of exclusions which are excluded from patenting. Okay, I'll move on. So these are all the sections under 3. Okay, A, B, C, D, F, G, H, I, like that we have come. J is also there. Section J. K is there. I is there. Sorry, L, M, N, O, P. Section 4. I told you earlier that exemptions you have to see in section 3 and 4. Section 4 is inventions falling within section 21 of the Atomic Energy Act 1962 are not patentable. Okay, anything connected with atomic energy not patentable. Invention relating to compounds of uranium, beryllium, thorium, plutonium, radium, graphite, lithium, and more, as notified by central government from time to time. So you can't go to the patent office and tell I want to patent. Not allowed at all. So main criteria for securing patents. So in a sum up, I'll tell you whatever I discussed. The following are the criteria. The invention must be new, and this means that the invention should not be known anywhere in the world on the date of filing of the application. The invention must involve inventive steps, that the invention must not be obvious to a person reasonably skilled in the field. The invention must be industrially applicable. However, in some cases, even if all the above criteria are fulfilled, still patent is not possible because of local law, like in nuclear transformation, treatment of human beings, plants and animals, like that. Again, country-wise, this law may change. Okay, America may have something different. Overall, there is a guideline, but specific when it comes to the law, each country may have some differences within all these aspects. Okay, so are there different type of patents? Yes, ordinary patent, patent of addition, and a patent granted under convention agreement. Ordinary means we are applying and we are getting, but you want to add to the existing something, that is what is a patent of addition. You can add something to the existing one, so that is called as patent of addition. Then when we say patent granted under convention agreement, for example, you have made one new product, you are filing in India, but same time you feel that it may have business benefits in other countries. So you can apply in other countries, but whose help you will take? There is one organization at the global level called WIPO. I'll come through that later. So that they have put in steps how you can you can file for patent in different countries through their arrangement. Okay. So patent right is patent for big inventions only. Now I'll come to that point. Okay, you may have in mind, if I take patent in India, is it global application? No. You are taking a patent right or whatever, copyright and all these rights are within the territory of that country. For another country, you have to take, you have to follow their law. Okay. So the benefit what they will give at the global level is WIPO, World International Trade Property Organization. So that organization in Switzerland, it will help you. They have put down the framework in such a way that if you identify the country, then when you apply here, same time you can make that application, and from that application it goes to the respective countries. Then in the respective country you apply for your right. Okay. So is it a patent for big invention only? No. Patent is applicable for even small inventions. However, shall meet the patentable criteria. So what is R&D, what are the patent rights, and what is innovation? You know, we do research, so all the research may not be successful, but whatever is successful, then we get the patent right, and when the patent is put in the market, that is what is innovation. Whatever brings in money is innovation, otherwise it is not actually. People confuse the innovation means anything, they use the word, but actually innovation means whatever it is bringing you the money. It can bring a substantial income through the manufacture or licensing of the invention covered on the planet. Okay, patent also represents a legitimate long time security to the whoever invents. So patent important facts. Is there anything like world patent or world trademark or world design or international patent or international trademark or international design, etc.? The answer is no. Even under TRIPS, there is nothing like global patent. The rights are enforced only in the respective country. Hence, separate applications have to be filed as per the rules and regulations and practice of the individual country. So, in the case of patent filed under Patent Cooperation Treaty, PCT it is called, okay? Remember this, PCT, Patent Cooperation Treaty, it is mentioned as international application with the symbol as WO. When you apply in India, you have to apply through that, then with the symbol WO, that is what the countries you have to identify. Then when it goes there, you have to pay the relevant fee there. If it is American and all, it will be in dollar. We can't do so easily. Okay, so that is what it is. So PCT is the route through which you can apply in several countries at the same time. So you'll have the priority. If you have filed today here in India, the same date applies everywhere. Okay, that is what it is. The Patent Cooperation Treaty, and it is WIPO is helping in this regard. So I'll skip this slide. Benefits of sui generis system. For example, nowadays a lot of MNCs are coming now. So the MNCs may be taking away our traditional knowledge and they may be making a lot of money. That is why this sui generis system is there, which is helping in the agricultural sector and in the traditional knowledge sector. So benefits of sui generis system is that it not only protects the community knowledge, but also help appropriate sharing of the revenue earned through such IPR. So the local people get the benefit of that IPR. In the end, I have the case study for this purpose I kept, so you'll understand. Okay, there has to be creation of knowledge of IP professionals and efficient legal system to quickly provide justice in case of IP disputes. Hence, the traditional knowledge TKDL, traditional knowledge digital library has been created. TKDL would play a crucial role in documenting India's precious traditional knowledge and heritage in the area of traditional knowledge and heritage in the area of traditional healthcare systems. So you may be hearing now Kashaya and now Giridhar Kaje, some of the things and all. So actually it is the Ayurvedic system. So it has to come under the traditional knowledge. So he has to file under this and keep it so that America can't copy. Tomorrow Trump may say that is my medicine or whatever Coronel our Ramdev, Baba Ramdev has done. So it will come all under traditional knowledge. Examiners of patents in the patent office globally will have ready access to Indian traditional knowledge while considering the prior art knowledge on the invention disclosed in the application for patents. So, haladi, turmeric, America can't take patent because it is already in our traditional knowledge digital library. So, if somebody American applies saying that I have haldi, some medicine for a human being, then it can't be patented. Reason being, it is already in the traditionally used in India. So, under sui generis system, it is taken care, and globally they know that it is protected in India by this act. So benefits of sui generis system, to begin with, the TKDL on Ayurveda has been taken up. It compiles the traditional knowledge from public domain in a digital format. Similarly, it is expected to cover other areas of traditional knowledge. Now provisional application and complete application. I'll quickly go to it. See, provisional and complete, the difference is in the complete, you will be whatever idea comes to your mind, but it is not that provisional means just the idea you submit. Idea requires the necessary overall idea. Idea means you have some product in mind, then you have to make the related drawings, rough drawings also may be okay, but you have to say the functional aspect of this is like this, then you have to say what could be the economical benefits and all those. So that is what is provisional. The idea comes to your mind, and without knowing what is the end result of it, but you have an idea that it may give this result, then you file day one. Okay. Then when you file, from that date to 1 year time, you will have to work further on that. And on the right hand side, when you say complete specification, so you get from the provisional to the complete 1 year time. But if you are ready with everything, then you file it as a complete specification in the beginning itself on day one. But if you are not ready with everything, your testing and all are not proven, then you can submit a provisional application, and from there, the day of filing to the next 1 year time, you will get to submit the complete application. If you see the end here, the last thing, claims. Are you able to see these claims? So this is what is the most important thing, which will not be there in the provisional application. So when you claim that, you are saying that these are all the things so far in the public domain, it's not there. So I have done this addition in my machine or whatever my product. So this is what is my claim. So anything controversy coming is on these claims, and people go to the court based on these claims. So when we say the complete application, it will be with these claims and all the related drawings. So it is complete in all aspects you are filing. Okay. So you can file a provisional application if you are off baked in that relating to that product. You know something off, then you can make a provision application. But provision also requires some of the important things. But when you say complete, it's complete in all aspects, and they won't look into it further, and they will look into the inspection of that. Okay, they will see that you have said this product is complete in all aspects. Then it go for some inspection later. Okay, as a product or as a process. So, is there any prescribed format for preparing a specification? There is no, but there is a format available in the whatever I told you now. You can download from the patent office. There is a booklet available. So in that some format is available, or you can make your own format. But there is forms are there. The forms have to be followed. Forms and fee are very important. The form numbers are there. Particular number for particular action is there. So you should not miss, because government, as I told you now, section number, this number, that number, you have to follow those numbers, and accordingly you have to follow and pay the fee. If the fee is 2,000, you can't pay 1,999 or 2,000 whatever. It has to be perfect. Okay. So these are all the things. Now, how much it will be, how many years it will take? You see, from 0 to 4 to 5 years it will take. Okay, 0 means you will not get the patent, but year 0 to year 2 to 4 to year to 4 to 20 later. Okay, 4 to 5 is so year 0. How much is the expense? So patentability search and all these things. Initial application may cost you to 25 to 35,000 rupees. Okay. When it is year 1, patent application drafting plus filing 49,000 to 1,03,000, like that. It depends upon the area of work, and it depends. It may depend on the patent agent who takes up your work for filing. Okay, but it is really expensive. It's not so easy. Let me share your experiences. I have one multiple biocid decorticator which has been filed almost 3.5 years back. Now it is coming to 4 years. So they ask for examination. So I have already spent 25,000 on that. Now again I have to for examination. If I don't do examination, it is lapsing and it will be abandoned. So if I have to do examination, I have to spend another nearly 25,000. So you can say that for my, if everything goes well, I get a grant, I would have spent almost 50,000 as such. Okay. So another, it is now before January, I have to go into the next process of examination. That's what you see in the year 2 to 4 examination process. So there will be the related fees and also fees of that patent agent. All put together, it could be for 2,000 to 76,000. Year to 4 to 5 patent grant, there will be some small expense. So after that is granted, then year 4 to 20, in the year first 2 years you need not have to pay, but the third year onwards you have to pay every year whatever the government is has fixed that. Okay, I think it is clear to you. So I have taken some of the information from Patent Office, Deputy Controller of Patent and Design. Okay, so obtaining a patent, I think I will skip all this. I'll just show you through the process. Okay, a simple process I'll show you. Okay. Filing of application, provision are complete. So if provision specification is filled, complete specification to be filled within 12 months. Okay. Then publication of application. Up to 18 months, it is kept very top secret. Then after the 18 months, it is published. There is a Government of India, some patent office, some book is there, journal sort of thing. In that it gets published. Okay. The essence of that. Then within 48 months from the filing date, you have to request for examination. Okay, that's what I told. My patent filing to this coming January, it would be 48 months. So now they have asked for examination. If I don't say I don't want exam and nobody is asking for exam, then it is gone. It is abandoned. So the examination I have to tell, or some competitor can tell. Then that is the way it goes for examination. So if competitor comes for examination saying that it is infringing on my patent, then competitor can tell the patent office that it has to be examined because it is infringing on my patent. Or if nobody is coming forward, then I have to only go for examination of that. So that is done within 48 months. Then after that, examination first information report will be submitted by the examiner. It is a third party representation. Okay. Then all objections to be completed within 12 months of that. Okay. That's what 4 to 5 years. Then a patent is granted. Then within that, after the grant also, there is people getting the time to oppose it. Once the patent is granted, if somebody has objection, they still can oppose within the 12 months period after the grant. Then the controller can decide. After the decision of the controller, if the parties are still not happy, then that goes to the appellate board. Okay. So the appellate board will decide whether the patent has to be revoked means taken back by the party, or it has to be amended. That will be decided. It is not going to the court. Okay. There are some appellate board, because courts are overburdened with this type of thing. That's why they have fixed some appellate board. Of course, if the appellate board also is not able to do it, then only it will go to the court. A renewal fee to be paid within 3 plus 6 months from date of recording in the register. No fee for first and second year. Renewal fee on yearly basis is required to be paid for third to 20th year. Delay up to 6 months from due date permissible on payment of fee for extension of time. Actually, patent lapses if you don't pay after beyond 6 months. Means third year onwards, no. If you don't pay after 2.5 months, after 2.5 years, you don't pay for the third year, then patent lapses. Then it is going to the public domain and you lose the right. So, word of caution: what is patent infringement and plagiarism? So, plagiarism means somebody stealing your this thing and they are making it. That's why you have got a right to go to the court and to protect your property. So, for example, in 2009, the US court gave infringement penalty of $. You see, what is that? Billion, 1.67 billion. So, a company can go bankrupt by paying this much of infringement penalty. This is what the penalty in the US. The law is so strict. The largest patent infringement award in history to Centocor, a subsidiary of Johnson & Johnson, against Abbott Laboratories for Humira, a rheumatoid arthritis drug, which infringed with the technology license agreement Centocor had with the New York University. Okay, so this is what the law is so strict there in the US. Even in India nowadays they are catching up actually. Okay, so these are all infringement thing means, you know, now as the students plagiarism check for whatever you do, the project report and all is very important. It's like infringing on others. So that is why plagiarism check the university or the college puts, it has to be below 25%. Similarly, somebody's work, you can't claim that that it is my work and make a business out of it. So they can go to the court and the court can put a heavy fine so that the company itself gets closed. That much will be a huge fine. Global support on IP rights. I told World Intellectual Property Organization is there. So this is what is in the Switzerland, and they have for all type of things international patent system. That is what Patent Cooperation Treaty. So they help in that regard, and the international trademark system also is there where they will help. The international design system also, design means aesthetic, for that also help is we can get. The international system of appellation of origin, that means geographical indication of that also you get help of the WIPO globally. Similarly, alternative dispute resolution. Similarly, any dispute at the global level comes, this WIPO, World Intellectual Property Organization, will help you. Okay, domain name. Now you must have come across like domain name is a very serious problem. You know, www.shashikant.com, if I put and if it is already there, or if somebody puts, that is where it becomes a big problem, and that goes to the court. Okay, somebody alternatively they can't create. If they create, there will be litigation. So domain name is a very, very important thing. For example, we have ICET, International Conference on Emerging Trends in Engineering. We have been using for the past several years. 2 years back or so, some other institute or some other organization, they took objection. But then we proved that we have been using it. Otherwise, we are not allowed it. Okay. So that is what is the meaning of domain name. Okay, so WIPO has their offices in India at several places for all those aspects of intellectual property rights. I will not go through the details. Case studies. Quickly, I will finish this case studies. Okay. Now, in Bangladesh, although Bangla is the 7th most spoken language in the world, there was no well-functioning, simple and easy-to-use software for typing in this language until the late 1980s. You know, Bangladesh is a poor country, so other countries will not have much interest in doing that. So what happened? One Mr. Jabbar, He is from a rural village in Bangladesh and would later attend the University of Dhaka, where he majored in Bangla language and literature. He began his career as a journalist in 1972 while still a student. Then he started a computer business in 1987, but technological limitations were particularly constraining for the printing and publishing industries in Bangladesh and other Bangla-speaking regions. So he couldn't find a proper keyboard, so he developed a keyboard. Okay, so what happened? He chose to name this keyboard, and the entire Bijoy. Bijoy means in Bangla it's victory. Victory corresponds to the that date when he has done and all. It is the liberation of Bangladesh from Pakistan. Okay, so that is why Bijoy has kept a victory, and that has been recognized. This work has been recognized by the United Nations Education Science means UNESCO declared the date International Mother Language Day. Do you understand? It's his brainchild. He has developed this keyboard so much with a lot of difficulties. He has come out with this keyboard, and UNESCO has recognized, and the day is called International Mother Language Day, in tribute to the Bangla language movement as a part of the growing recognition of linguistic and cultural diversity around the world. This fellow later, in their country, he wanted to patent. Of course, as per our law, not allowed, but somehow he was able to. Initially, when he applied for patenting of this keyboard, there was nobody to come forward. But later somebody came forward. That's why he has got a patent for this also. And later he was made the minister. He was made a minister in the Bangladesh government. 2018, Mr. Jabbar was appointed as Minister of the Ministry of Post, Telecommunication, and Information Technology in Bangladesh. So he has licensed it, and now it has become very popular. It's making a lot of money. So this is what you have a product and you work on it. You do research, develop, and finally you make a product out of it yourself, or you license it to somebody, or license it to several people. Then you make a business out of it. That's how you grow bigger. So when we talk of startups, that is what is the thing. It's not a small business. You you have a business idea, you develop in a huge way, and become a very big business. That is what when we say the word startup means that. Okay. Now that is what about Bangladesh. Coming to India, innovating safer travel. I don't know, you are all young, but when we were there, for example, which any one of you can tell which is this? You can imagine which is this railway track you are seeing here. Of course, it is through the valley like thing you are able to see. Okay, one is our Sakleshpur route and all, or the other is Konkan railway route. Of course, this is Konkan railway route. Okay, so one doctor B, I think Mr. B Rajaram. I was in Bemel earlier. I have come across this Mr. Rajaram. So he is a great man. He has a sky rail also he has developed. And another thing what he has developed, we used to hear a lot of train accidents, and Konkan Railway used to have accidents in such a way that people were fearing that this line has to be permanently closed. But you see, after his invention, the things are not at all. We are hearing anything from the Konkan Railway. How he has developed. See, he is Rajaram. Okay. So there used to be a lot of accidents. So he thought that in the age of instant communication, powerful microprocessor, and a global position system, there must be some way to develop a fail-safe protection system. So he designed a device which would be mounted on trains and stationary objects such as crossing guards that would communicate with each other through radio to accurately assess a train's direction and speed. If a collision was imminent, the device would initiate automatic braking that starts 3 kilometers ahead of a possible collision point. Determined to put an end to unnecessary accidents, he gave himself a warlike target of 90 days to produce the first anti-collision device, ACD, its prototype for use with the trains. Okay. So how he got the idea implemented? Mr. Rajaram found that when his grandson, where he was playing with that whatever he has done, changed the direction. His grandson was working on that, and then he found that it changed the direction. That's how he got the idea. The GPS immediately showed the corresponding change in angle. He thought that if the GPS is sensitive enough to detect such a small change in angle, then a technique could be developed to use this angle change to mathematically determine the speed of a train. After a few weeks, he developed the deviation count theory, which can accurately determine vital train data such as speed and direction using GPS data. This innovation led to the creation of his anti-collision device, Raksha Kavach. That is what RKACD. named after a powerful talisman for protection. These are all the things you can see. Physical device, Mr. Rajaram's ACD system has been developed for mounting on the front, that means top, and rear, middle of a train, and at a control station. So it has to be at 3 places. Okay. So this is what. So it was not so easy for him. He continuously did the research and development. He took eminent scientists to help and all. So this innovation led to the creation of his ACD, anti-collision device, Raksha Kavach, that in short RKACD. So he got the patent also. Okay, according to the Price Waterhouse Coopers, potential royalty from Mr. Rajaram's patent was roughly US $1 billion. It is a few years back. Okay, so this is what he had earned the royalty for his thing patent, but he sold because he's so much a social conscious. So he wanted that technology to be given to the railways. So railways happily took it and they have made it a patent. Okay, they call it RKACD. They have patented, not only patenting, they have implemented, commercialized it everywhere, and they have implemented. And you see the train accidents have come down considerably. Almost no accidents these days. We have largest network in the world, but this has reduced the accidents like anything. Okay, so this is a great invention. It has led to the business business result. The innovation RKACD network made possible through Mr. Rajaram's deviation count theory has met with much success. By 2004, the entire 760-kilometer Konkan line between Roha, a small town southeast of Mumbai, and Tokur, our Tokur here, Mulki. Okay, Tokur, the southernmost stop on the line, had been protected with an RKACD network. It has also been installed on over 1,700 kilometers of NFR track. RKACD technology has enjoyed significant domestic and international press. And press means a lot of it became so popular, and in the National Geographic channel and everywhere it had come. So it got so much of wide press all over the globe. Okay. The Indian government also has plans to assist with the implementation of RKACD system on all railway lines in the future. So another thing in Kerala, using traditional knowledge to revive the body and community. Body means our own body, using some leaves, one sort of it is not medicine exactly. It is like a layer. It's a complementary thing they have prepared through a leaf. Okay, like that. It was known to that one particular community in Kerala. Okay, so that one organization, Tropical Botanical Garden Research Institute, took it and they did the research, and finally it has been made into a product, and the product is marketed, licensed to that. The committee chose Arya Vaidya Pharmacy Limited of Coimbatore. So they are the very famous company. So they sold this, not sold when they licensed to them to make the product, so that given is available in the market, and the money comes, the royalty comes, good royalty comes, and this royalty is used for the benefit of the local people, as well as it is now commercialized. So good business is coming out of it. And there are concerns that when they remove these leaves and trees may get dried, and those concerns also have been addressed by this agency. So it is really a sustainable thing. That is what is happening in Kerala. That is how the traditional knowledge is also protected, locals are also protected, environment is protected. That's how it becomes totally sustainable. So with this, I'll end my talk. I think I've taken much time. So thank you all. So if you have any questions, please ask. I hope it was useful to you.
Thank you, Dr. Shashikant, sir,
Yeah.
for your informative session on IPR.
Okay.
Okay. Thank you very much. I request participants to share your questions through chat box, or you can ask questions directly. Any questions?
Anybody has any question, please ask. No questions?
Please kindly ask the questions with sir if you have any doubts.
Somebody is talking or?
No, sir, it's me, Balaji.
Okay.
Okay. I think, sir, we don't have any questions, it seems.
Okay.
The kind information in such a way that we have shared the attendance sheet, like it's a form, Google form. Kindly fill it, check with the USN part. It's accepting right now, it seems. I have changed the settings and all. And one more thing I would like to say, this is for your certificate preparation. I think we have collected the responses, many responses we have collected. I think only 20 to 24 responses we have collected. The others, if you are not accepting the USN number, you can kindly fill it once again if you want.
So everybody, okay. One thing I want to tell them that this is how when we talk of everything may have solution. So we have to really think, and then there will be some solution. That's what I told you some that Bangladesh case or Rajaram of railway or that Kerala thing. So that is one relating to computer development of the keyboard, and the other one is the development of a product for railway. Like that, it's a product, and the third one is the traditional knowledge. Likewise, several cases are there. It can't be covered within the short time. That is why I thought how it is a small idea will enter, it will grow into such a big business. That is what I wanted to cover here. That is what in line with my presentation. That is what IP rights, then technology transfer, and this one. What is that? Startup. Okay. Okay. Fine. Okay. Yeah, Professor Karthik Pai wanted to tell something.
Formally, I thank our coordinators and resource persons, Professor Shashikant Karinka, Professor Nasim Belkere, Dr. Anil Kumar, Mr. Balaji, for supporting us in smooth conduction of this program, and also as a resource helped us in conduction of this program. I thank our beloved principal, Dr. Niranjan Chibnukar, for supporting us in materializing this awareness program. I thank our anchor, Mr. Balaji N. For 4 days, he has managed both answering the program for all the 4 sessions, and also supporting students in filling their attendance and getting their feedbacks. I thank all the participants for your patient listening. I thank one and all. Over to Mr. Balaji.
Thank you, sir. Thank you so much. Sashikant, sir, thank you so much for your wonderful session. It was completely informative. We haven't missed anything from your particular slide. Then thank you all the participants. And I should like to thank Dr. Karthik Pai, sir, giving an wonderful opportunity to host the entire 4 day session for all the students, as well as a resource person. I was also there in the day 2 session. Thank you so much, sir. Thanks for your opportunity. Thank you, one and all. Thanks for your cooperation and the smooth conduction of this particular awareness program for the students. Thank you, one and all. Thank you, sir. Thank
Yeah.
you.
Just a
We
moment.
will
Let me also.
certificates within 1 week to all the participants.
Okay. Professor Karthik Pai, let me also thank you and
Thank you,
Professor
sir.
Balaj. Thank
Thank
you
you.
all. And then,
You have attended all the 4 sessions. Thank you very much for your support.
yeah,
Thank you,
thank
sir.
you very
Thank you,
much.
sir.
Thank you
Thank you,
all.
sir.
Okay.
Thank you. Thank you,
Thank you,
sir.
sir.
The last and then one more thing we would like to share, the certificate part. The participation certificate will be distributed within 7 working days. It is going to compile I think maximum number of students are there. Okay. I think I will be opening this particular form around next 5 minutes. By 12 o'clock, I will closing this form. If anybody is did not filled, please do filling the form as soon as possible. Thank you so much. Thank you, one and all. Thank you to all the cooperation and support. Thank you. Thank you so much.
Thank you.
I can leave the meeting now.